Happy New Year to all our friends, colleagues, and students. On behalf of the Institute of International Shipping and Trade Law, which is a research center in the School of Law at Swansea, it's my pleasure to welcome you to our first webinar of the year. In fact, we are planning a few other webinars in the next few months, and the next one will be on 11th of February on distributed ledgers and blockchain in shipping and commercial law, led by Professor Sarah Green, the Law Commissioner, Simon Rainey, QC from Quadrant Chambers, and Professor Tettenborn and myself. So we hope to see many of you there as well. After this advertisement is out of the way, let's move on. We have been talking about Brexit for the best part of the last 5 years, and numerous speculations have been made during this period as to what legal rules will govern commercial and maritime law and contracts following Brexit. In some rival jurisdictions, understandably, there was an expectation and perhaps hope that following Brexit, the significance of London as a maritime and financial centre, and English and Welsh law, of course, as preferred choice of law for contracts would diminish. I personally do not think that will be the case, but now we have an agreement between EU and UK, a legal standing to regulate the relationships going forward. It is time to discuss in an informed way how things will pan out. This is precisely the intention of our expert panel today. First of all, Simon Crowell, QC, will talk about the impact of Brexit on maritime disputes and dispute resolution. As you appreciate, this is a matter very significant for all lawyers working in London. Simon is a leading silk and also the head of one of the most prolific commercial chambers in London, Quadrant Chambers. Immediately after Simon, the other Simon, my colleague, Professor Simon Bowen from IISTL, will deliberate the impact of Brexit on maritime rules. He will especially discuss which parts EU law we are likely to retain and which parts we are not. And that promises to be a very interesting analysis as well. Last but not least, my good friend and leading European academic, Professor Athanasiou from Athens University, will enlighten us on the potential role that UNCITRAL model law could play in dealing with cross-border insolvency issues going forward. This is an issue which will no doubt have an enhanced significance after Brexit. Each speaker will be given 20 minutes to present their case. And I'm hoping we shall have 10-15 minutes at the end for questions. Please put your questions on the Q&A part of the server. And at the end of the talks, I shall direct them to the relevant speaker. Please enjoy the afternoon. I'm sure you haven't come here to listen to me. So could I ask Mr. Simon Crowell, QC, to take the floor, so to speak? Thank you.
Well, good afternoon to everybody. Thank you for the invitation to speak today. I'm grateful for that invitation and to speak on a subject on which this isn't the first occasion I've had to address it. Indeed, one or two people here will know that I've spoken before, because back in March of 2019, Barris, as it happens, invited me to speak in Athens on this very subject. It seemed then like a pressing topic, something that was ready, we should really ought to be ready to discuss, because we were due, as at the end of March, to leave the European Union, and then we would have some clarity. Well, as we know, it didn't work out that way. And like so much to do with the post-Brexit future, it's taken some time for us to have any idea what it might look like. What was clear is that we were going to be taking a different course, that is to say, the United Kingdom, and the legal rules may well be impacted in that respect. Now, one might hope that now that we have not only left the European Union, but the period of transition, which I'll mention briefly in a moment, has come to an end, and we now have a form of trade agreement we will have clarity in relation to exactly where we stand in relation to the issues that I'm going to grapple with, which will be to deal with jurisdiction and enforcement in relation to maritime disputes. Well, that's a hope, but I'm afraid it's not one that I can guarantee I can give complete clarity on. There are still a number of matters which remain to be resolved, and I'll identify those as we go along. Where with confidence I was always able to say that things would not change, that remains just as much true now as it was then. However, where with confidence one said that there is a strong chance of change, well then there is still some lack of clarity. I can tell you with clarity what's changing, what's going, and that is the recognition, the recast regulation, which is the latest iteration of the regulation by which the jurisdiction rules and enforcement rules between the EU countries and states are harmonized. Well, that it will fall away. What is considerably less clear is over the longer term, what might replace it. It may be, in due course, its older and less sophisticated sibling, the Lugano Convention, but it isn't for the moment, because although the UK has applied to accede to that convention, it has not yet acceded to it, and it is not yet clear whether it will accede to it, although I'm sure that is its aspiration. At the moment, at least, it's replaced by a mix of regimes, a more narrow convention covering exclusive jurisdiction agreements, the Hague Convention, and existing English common law procedural rules, supplemented by some bilateral conventions. Now, the changes to jurisdiction enforcement represent the most important and significant changes, and they will be the focus of my talk about changes. However, it's also important to point out what in the context of maritime law has not changed, because there is a great deal which has not changed. And I'll come to that in a moment. First, can I deal with some context? I'll take this quickly because in a sense, this is simply there to help you understand why we're having this discussion. Back in 1972, after the United Kingdom joined the European Union, the European Communities Act was enacted. The significance of that was it handed over some legal competencies, the power to make laws, effectively to the European Union. The UK's participation in international agreements and treaties was done through the EU rather than individually, and many, at least some, of UK laws had to be harmonised with agreed EU laws. Now, those phenomena arising out of the 1972 Act are going to change. Not all of them, but some of them. The treaties will all cease to apply and have ceased to apply from 11 p.m. as it transpires on the 31st of December last year. By contrast, the directives, the EU directives, have to be implemented into UK law by statute. And indeed, the UK has taken the course of reenacting into UK law all of the existing EU law that came by statute, so that in fact, the UK law resembles strongly what it was before, whilst the UK was within the EU. That's through the means of the European Withdrawal Act. However, that thing alone does not mean anything will change. Some of the laws and regimes require what's called reciprocity. That is to say, for the UK and the EU, acting through it, all its members, to carry on as if nothing had changed and to treat each other as if nothing had changed. Well, in the world of jurisdiction and enforcement, that requires reciprocity, and that is the main area where change will take place. But before I move on to talk about change, let's talk about what hasn't changed. But before I do that, I just wanted to mention one thing. As many in the UK will be aware, perhaps we're all aware, in the nick of time, almost literally in the nick of time, before the transition period, that is to say the period up until the 31st of December 2020 expired, the EU and the UK struck a trade agreement. Now that trade agreement may cover a limited amount of matters, but there is one important thing that you need to understand, is that it is silent on all matters to do with judicial cooperation. Whatever else it may achieve, it does not put in place a future regime on jurisdiction enforcement, or even provide a signpost to the future in that regard. So what we're left with is what we have from the withdrawal agreement, what's been saved by the latest EU Withdrawal Act, and what effectively is left once everything else is taken away. Now, those are the discussions as to what's changed. It's also necessary to look at what hasn't changed. And what hasn't changed is, in the context of maritime law, really quite important. The first big point that I think is worth making is that there is no change to substantive law. Maritime and commercial lawyers are almost exclusively concerned with disputes to do with contract and tort law. The underlying contract and tort law, whether it be embedded in statute or common law, is totally unaffected by Brexit, insofar as its membership of the European Union up until the end of last year has affected that English substantive law. Well, it will remain English substantive law. English substantive law has reenacted it, so there is absolutely no change to that. And perhaps a striking example of that is the fact that even the question of which law is the applicable law will continue post-Brexit to be determined on the same way as it was before, applying regulations which emanated from the European Union and are applied across the European Union. That is to say, the Rome I regulation to do with the contracts, to do with the applicable law in relation to contracts, and Rome II to do with applicable law in relation to non-contractual obligations. Now, those have been enacted as part of the UK statutory regime and can be applied, and they will be applied. Now, that works because in Rome I and Rome II, the so-called reciprocity, everybody treating each other the same, is not required. They're bound, both parties are bound to treat each other the same by their own laws. So that doesn't matter, so it can be retained. So that's a good example of how of important things that do not change. In fact, it's fair to say that unless and to the extent that UK law is influenced by EU law or treaty obligations, it will be unaffected by the departure of the UK from the European Union and the legal consequences of that. An excellent example of that, and a highly relevant one in the context of this discussion, is London arbitration. UK arbitration is regulated by UK statute, the Arbitration Act 1996, UK common law, and insofar as we're concerned with the enforcement of arbitration awards, an international convention, that convention being the New York Convention, the New York Convention on Enforcement of Foreign Arbitral Awards. That was joined by the UK before, it was entered into by the UK before it joined the EU. It's a party in its own right. So nothing is affected by the departure from the European Union. The consequence of that is, if you're concerned with, or may be concerned with arbitration, the departure from the EU, the end of the transition period, will make absolutely no difference to the way that substantively anything takes place, or procedurally anything takes place. There is no change. So that's an important no change point. The other, and if one thinks about it, I think, and this is a relevant consideration, I think, Barish mentioned in opening, one of the reasons we're having this discussion is because London is such an important dispute resolution centre. I've suggested in the slide in front of you now a series of reasons for that. And I'm also going to suggest to you that actually of those reasons, only the final two are conceivably affected by Brexit. It's fair to say that in relation to the final one, enforceability of judgments and awards enforceability is not affected, so it's simply only judgments. And the fifth relates to the sense in which London as a dispute resolution centre is influenced by its ability as a business service centre. Now that might be affected a little bit because the free trade agreement is notoriously quite silent on questions to do with services and the City of London. But on the whole, there's no reason why London as a centre should be significantly affected. and its significance and importance is reflected in this slide, which I give you here, which is the latest 2009 numbers, 2019, not 9, numbers for arbitrations commenced in London as compared to other major forums. Many of you will be familiar with it, but the numbers are striking. It is obviously the major forum for maritime arbitrations, and there's no reason why any of that will change. Which brings me to the big substantive legal change, which is worth talking about, and I will focus the rest of my discussions on, and that is questions of jurisdiction and enforcement in court proceedings. Now that regime has, until literally midnight of last year, been governed by the so-called recast regulation, which is the latest iteration of the jurisdiction and enforcement harmonization regime. It does two things, as the slide shows: common basis for determining where parties can sue and be sued, and a common basis for recognizing and enforcing judgments. It is what, as I say, in various situations has been in play for now a very long time. It operates, this operates on a reciprocal basis. It requires each of the member states, of the contracting parties, to apply it commonly in relation to disputes that come before us. That is what has existed. It was supplemented, and of course these conventions still exist, by the Lugano Convention of 2007. The Lugano Convention actually is in largely the same form as recast. It is an earlier iteration of it, but extended beyond EU countries to just a few others: Iceland, Norway, and Switzerland. Unlike the recast regime, it is open to be joined by non-EU members. Hence, the UK has made an application to join it. But fundamentally, it's a very similar regime to the recast regime. So those are the regimes which have gone. Those we were party to because we were members of the EU by treaty, and those have fallen away. What are the UK's options to replace them? Well, essentially the two: to accede to Lugano. The UK has applied to do so. It did so during the course of last year. The non-EU states are perfectly comfortable with that. Thus far, the EU appears not to be comfortable with it. I'll come to that in a minute. The further alternative is accede in its own right to the Hague Convention of Choice of Court Agreements, and the UK has done that, and we're now in our own right a party to it. I say in our own right because we have been as members of the EU for some time. Now, the revised Lugano Convention, we've applied, as which that slide indicates. The Commission appears less convinced of whether we ought to be allowed to join, but the key point to understand is that all EU members have to agree, and the second point to understand is that they have not yet agreed. It may be that a trade deal will lead to a reconsideration of that position, but it's also fair to say the trade deal says nothing about this. It's fair to say it's possible, especially with everything else going on in the world, this has dropped off the agenda for the moment, and in any event it will take months for an accession to take place and for a new regime to apply. So as we sit here now, we have not signed up to the Lugano regime. If we had, there would be differences between Lugano and the recast regime, i.e. what went before it. The two key differences, and I won't explain these in detail now because time won't allow. One of them is that under Lugano, the courts are not bound to apply decisions of the European Court of Justice. They just have to take account of them. To what extent that really gives them latitude in the world of reciprocity, I don't know, but it certainly in theory does. And there are various other features, of which perhaps the most talked about is the so-called Italian torpedo. Now that sounds like a rather colourful thing. What it really is it deals with circumstances where you have an exclusive jurisdiction clause. The old Lugano regime, unlike the old Brussels regime before it, said that the court first seized had to determine whether it should accept jurisdiction, and that meant that when a court who had an exclusive jurisdiction clause in its favour always had to wait for that. That gave us some rather tactical manoeuvring by some parties in applying to other courts just to waste time, That's the so-called Italian torpedo. In recast, they got rid of that by recasting, quite literally, these provisions. Locarno doesn't, so we may see the Italian torpedo get a lifeline, and we know it's alive and well because the English Commercial Court, in the decision on that slide, the Mastermark decision, said so in a relatively recent decision. So that's what would happen if we went back in, but all of that is rather hypothetical at the moment because we haven't gone into the Lugano Convention. Unlike that, we have signed to the Hague Convention. We are now a signatory in our own right, having been a party prior to that as members of the EU. Now, the Hague Convention is more limited in its scope. As the slide indicates, the signatories are the EU, Mexico, and Singapore, but for present purposes, it's the EU, which we'd be interested in because this is a replacement. And it applies, in its scope, it's more narrow because it applies only to exclusive jurisdiction clauses. And importantly, that is pure exclusive jurisdiction clauses. So the so-called asymmetric clauses, i.e. clauses for which jurisdiction is exclusive for one party but not the other party, is indeed an example, is asymmetric and would not be caught by that. But if you do have an exclusive jurisdiction clause, well then all of the state contracting parties will enforce both the jurisdiction clause and enforcements derived from it. So it is an important document, but only for those with exclusive jurisdiction clauses. There's a possible lacuna. I mentioned this briefly because of materials that came out last year. The UK only became a member of its own right as of January, although it's been a member through the EU since Hague came into force in January 2015. Now, the UK has specifically said it's going to apply Hague from the beginning of its coming into force, that is to say, all contracts from January 2015. The EU Commission, but only the Commission, have indicated a rather different position in a notice to stakeholders, in that they say that only contracts as concluded after the transition period will, in their view, fall within it, because only then did the UK become parties in their own right. Now, whether they're right about that is quite another matter. It seems to me, as a matter of logic, they probably aren't, because the UK have been a party, albeit through the EU, for a long time. But it's just another little bit of uncertainty to deal with the jurisdiction issue, which is yet to be resolved by any courts. Should add that nothing the Commission says is binding on any court. So that leaves us with the default position, which addresses what's left, where it is you aren't addressed by Hague, and that in effect is jurisdiction by means of service, and that requires parties to apply to the court, demonstrate that it falls within any of the court rules, and then once you have then served validly in accordance with that, well then, subject to arguments about foreign non-convenience, you found jurisdiction. And this is a more cumbersome and quite a different way to what's existed before. We needn't jump onto that yet, come back. But it works perfectly well with other countries, so it isn't necessarily the end of the world in that sense. But it's certainly going to cause what I'll call transitional problems, because the UK courts have not had to give permission to provide service out in claims against EU states for a very long time. They're not used to having to do so. As of the 1st of January of 2021, they will have to do so. There'll be a huge burden of additional applications that they have to address. So quite apart from the difficulties it may cause to parties, there will be logistical issues to courts in the next few months. And indeed, for those reasons, the transitional provisions, which I'll mention in a moment, became particularly important. Enforcement. Enforcement goes hand in hand with jurisdiction. The truth is, the options for the UK, with recast having fallen away, are the same options as there are in relation to jurisdiction, and the solutions will be the same. At the moment, we have the Hague as the solution. If you're outside Hague, you need to look at the default position, which is what this slide addresses. In relation to that, there are very few pre-existing bilateral treaties, and that is, I think, worth bearing in mind. That's no great surprise because we've been governed by the EU regimes for some time. Having said all that, In almost all EU states, it is perfectly possible to enforce your judgment. It is just much more likely to be more cumbersome and time-consuming than it was under the old regime. And to that extent, it might make a London judgment less valuable than it was beforehand, but it oughtn't to make it impossible to enforce, just more complicated, which is not ideal, and all the more reason why the UK wants the Lugano regime. Some transitional arrangements, let me just develop those for a second. They're covered by the withdrawal agreement. Put in very simplistic terms, the position is as follows. If you commenced your proceedings before 11 p.m. on the 31st of December last year, you'll be governed by the old rules, i.e. you'll be within Brussels or Lugano if you fall within those. If you commence proceedings after that, you'll be governed by the new regime. So if you're not within the Hague rules, you have to fall back onto the pre-existing common law rules. And that's the reason why there is a current deluge on the court, as many claims will have to be the subject of applications which were not, which were not in the period immediately before it. So that's those are the core transitional arrangements. A word or two about a couple of other things. Anti-suit injunctions. Now, in the London legal landscape, the anti-suit injunction, that is to say, an injunction to prevent a party not to commencing proceedings or continuing proceedings in another jurisdiction when it has agreed to jurisdiction, either by London arbitration or London court proceedings, is a familiar concept. However, it is a concept that has been held in the West Tankers case to be incompatible with both the recast and the Lugano regimes. So the question arises, might it now re-emerge now that neither recast nor Lugano is the applicable regime in the UK? Well, obviously, it won't re-emerge if the UK exceeds Lugano, but a different question arises, whether it can really work consistent with the Hague regime. The Hague regime is not the same as Lugano or recast, but it has some similarities in the context of exclusive jurisdiction clauses. And there may be a debate to be had, an argument to be had as to whether the anti-suit injunctions are really compatible with the Hague regime. And it will be, in many cases, the Hague regime cases where the anti-suit injunction is the obvious candidate. So I think the jury is still to some degree out as to whether anti-suits will really reappear, although they may reappear in the contract of arbitration, and I see more scope for that. So in summary, Brexit's impact should not be overstated for those in the maritime sector. The arbitration is unaffected. If we exceed, ultimately, when I say we, I mean the UK, and England and Wales perhaps more strictly exceeds to Lugano, there will be very little real change. I've flagged up the potential differences in my slide a little earlier. Even if not in high court actions where security has been provided, jurisdiction will have been agreed, and in high court actions where there is an exclusive jurisdiction clause, if the UK exceeds, when the UK exceeds that, I shouldn't say if, that's an old slide, they will be enforced. So there will be a small number, not an insignificant, but a small number of cases where the sorts of matters that I've just raised will become important. But there'll be very many in the maritime sector where, in fact, although we might feel there will be lots of change, in fact, the changes will be much more limited. So it's important to be aware of them, but it's important not to overstate them. And that's all I wanted to say. Thank you very much.
I'm now going to continue after Simon Kroll's presentation with a more general look about EU maritime law after Brexit, and I'm going to start by getting my very first slide up, which is always a help. So, Brexit has been consummated with a last-minute free trade agreement from the EU, our little Christmas present. And before that, before the 1st of January 2021 this year, when we completely exited the EU and the transition period had come to an end, we had the EU Withdrawal Act, and directly applicable EU law, such as EU regulations, got converted and incorporated into UK law, and domestic law through directives has been preserved as it exists immediately before exit from the EU. So does that just mean that everything which was EU legislation now just becomes UK domestic legislation? Need I say more? Well, I think I do, because that's why I'm giving a talk today. Yes, as regards EU maritime law, I'm going to have a quick overview of what are the main features of EU maritime law. What is, in other words, what continues, what was, some things are gone, and Simon has already been speaking about the recast regulation, and Leah will, after me, be talking about the EU insolvency regulation and what we will now be doing instead of that. And then I'm going to have a look at what will be, what future EU regulations which will affect maritime law are in the pipeline in the next year, and whether we are going to decide to track that or not. And before I go on to the regulations, institutionally, two big changes. One, we're no longer part of EMSA. And secondly, we continue to be a member of the IMO, but we can act in our own right. We don't have to toe any EU line as regards how we participate in the IMO. So what is? So various pieces of EU law affect shipping law. And I'm going to just have a look at some of the ones which affect shipping law, but they have been amended so that they actually fit into the post-Brexit domestic legal order. We've got the Hong Kong Convention for the Safe and Environmentally Sound Recycling of Ships. And we've got a statutory instrument which effectively retains those provisions, but there has to be some modification to make sense in the new context that we're no longer a member of the EU. For example, with UK flags, they've got to use an approved ship recycling facility on a UK list of recycling facilities, not the EU's European list. And there's a new procedure allowing ship recycling facilities worldwide to apply for inclusion on the new UK list. And we don't necessarily have to take the same attitude as the EU to that. We've got rid of any references which relate to the UK as an EU member. And also we omit or amend inappropriate language, including references in the regulation to the Commission. Well, we're no longer bothered by the Commission. So, that's one of the amendments which has had to happen, but essentially, basically the same. We've got on pollution matters, we've got the Environmental Damage Prevention and Remediation Regulations 2015. Basically, this is the consolidation and extension of the Environmental Liability Directive of 2004, which got expanded in its territorial scope with the 2013 Offshore Safety Directive. I question how significant this piece of environmental legislation is in the maritime sphere, because most of the powers which are given to the SOSREP to remediate environmental damage in our waters are actually already existed under pre-existing domestic legislation. There is the ability to require compensatory and complementary remediation, which is getting a bit more towards the type of remediation which you can see in the US regime. So, if we wanted to, we could get rid of those powers, but I don't think there's anything not to like about having extra powers. And there's certainly in the implementing SI with the amendment that everything basically stays the same. There are various amendments, like a member state is taken to be included to the United Kingdom. I mean, it just won't work if that doesn't happen. I mean, it won't work as a piece of UK law. So various references which have had to be made to for this this directive, which got implemented in under Section 2.2 of the European Communities Act by statutory instrument. It's had to have some tweaking so that it now makes sense in our new domestic context. There's also quite a significant thing about the fact that the directive contains references to other EU directives, and also an automatic process of any further amendment of those directives and expansion of them. And we put a stop to that. You're going to have a cut-off point with the directives in force as of 10:59 on the 31st of December 2020. Next regulation is the Port Services Regulation 2017. I have written about that occasionally, and one of the things which I thought this was going to go in the bin. And certainly the government minister in 2017, John Hayes, who was addressing representatives from various UK ports, said that this was going to be for the bin after Brexit. Both John Hayes and myself have not predicted correctly. It's still with us. We've got a new statutory instrument to deal with it, and it removes or amends provisions which have no value, which some in UK ports might have regarded as being the entirety of the regulation, but that's not actually what it means. Confer functions on or refer to EU entities, and deal with reciprocal arrangements which are no longer appropriate. And there's also, you have to, with the Pilotage Act 1987, you've got to make amendments to reflect that the UK is no longer part of the EEA. So some tidying up on that. An interesting little one next is the International Convention on Civil Liability for Bunker Oil Pollution. That got implemented through a statutory instrument under Section 2.2 of the European Communities Act, 1972, and I've given you the regulation there. And the reason for that is that once the EU obtained competence over jurisdiction with the Brussels regulation in 2001, the member states were told, you've got to make a declaration if you accede to conventions, liability conventions which have got jurisdiction provisions in, that as in matters which affect the member states amongst themselves, that the jurisdiction provisions of the convention won't apply and the Brussels regime will apply. There's been no I haven't found any change to this implementing regulation. I presume that the relevant declaration which the UK did has just vanished into thin air because we are no longer a member state, and therefore we're no longer, that declaration no longer has any effect on us. But the bunker, be relieved, the Bunker Convention is still in force. Now, Now, another bit of regulation which we've got from the EU, which is staying in force in amended form, and it's going to be significant because I'm going to return back to this when I look at possible developments over the course of the next year which will affect this particular regulation, and they can be very significant amendments, which I'll come to in a moment. This is the regulation dealing with the need to monitor, report and verify CO2 emissions from merchant shipping. And we have modified this so that it applies to ships visiting UK ports. And so vessels which visit both EU ports and UK ports have to comply with both schemes. EU voyages and emissions continue to be reported to the Commission. With UK voyages and emissions, we have separate reporting to the UK Secretary of State. But as I've said, I will come back to this because there are going to be some changes to this possibly over the next year. And it'll be interesting to see whether the UK decides that it is going to track those through domestic legislation. What was, well, we've heard about from Simon, the Brussels regulation. The insolvency regulation has gone. A little amendment to the merchant shipping, the compulsory insurance regulation, where you've got to have liability insurance up to the levels in the 1976 Limitation Convention. The requirement there that you have, each state has to notify the others of infringements of the regulation, well, that requirement no longer applies as regards the UK. There's also the lack of loss of financial passporting. That's not something covered by the trade agreement, but what the insurance market has generally been reacting by establishing subsidiaries within the EU member states so that they can continue to underwrite risks within the EEA. And P&I clubs have done this by setting up subsidiaries in places like Ireland, Cyprus, and the Netherlands, so they will continue to be able to underwrite EEA risks. And on the 30th of December of last year, the High Court approved Lloyd's of London's application to transfer its EEA policies to a subsidiary company in Belgium. So that it doesn't seem as if that's going to be too much of a problem. A few changes as regards seafarers' qualifications. You've got a directive of 2005, which is to deal with mutual recognition by EU member states of certificates issued to seafarers from other member states, which must be accompanied by an endorsement by the recognizing state. And obviously, we're not going to be an EU member state anymore. There's also provision for certificates from non-EU countries may be endorsed under the directive of 2008. And what's going to happen is after exit day, the existing UK endorsed certificates enable UK seafarers to work on vessels flagged with EU member states. But when they expire, you've got to go under the 2008 directive procedure, and EU member states will have to write to the Commission if they want to continue accepting new UK certificates of competence. So that is a change there, which will affect seafarers who want to work on vessels flagged with EU member states after their existing certificates expire. There's also some changes to how the submission of security information prior to entry into EU ports will work. Article 6 of EC Regulation 725 of 2004 means that shipping companies, including ferries with passengers and lorries, have to submit security information prior to entering an EU port, and that's got to cover the last 10 port facilities of call. However, Article 7 allows member states to exempt companies which operate scheduled services between ports in their territory and that of another member state. So, that would have covered scheduled services, say, from Dover to Calais, to give something of a recent newsworthy item. Well, after exit day, there's no exemptions available for vessels operating scheduled services from the UK. You're going to have to do far more by way of submitting security information before you go to an EU port. The third part of my talk is what will be, or may be. I'm going back to the monitoring, reporting and verification regulation. In 2019, the Commission made a proposal that let's harmonise the regulations reporting requirements with those in the IMO's parallel regime, particularly with let's get rid of the need to report the cargo carried. Now, what has happened is that, particularly with the new, the replacement of Juncker with von Leyen during 2019, the EU has got very interested in the so-called Green Deal. And what we've seen is that this proposed amendment to the MRV regulation has led to counter amendments, very much, I think, encouraged by a document on the Green Deal in December of 2019. And this has led to a proposal that the MRV be amended so that international shipping from and to ports in the EU is brought into the emissions trading scheme as from the 1st of January 2022. And the European Parliament approved that on 16th of September 2020. So there's quite a good chance that this will actually be in force a year from now. What about the UK? Well, obviously the amendment to the regulation, if it comes into effect, won't affect us because it will have happened after the end of the transition period. The UK, as regards the emissions trading scheme, is going to consider a link between its own emissions trading scheme and that of the EU. And if it can't get a link, it will operate as a standalone system, possibly introducing its own carbon emission tax. Now, there's no indication of how either of these approaches are going to deal with the question of emissions from international shipping. And one thing which would be very interesting to see is whether by the time the UK is hosting COP26 in Glasgow at the end of this year, whether it will want to appear that it is not adopting a similar provision as regards its emissions trading scheme. Finally, the European Parliament had just approved a new draft regulation on civil liabilities of operators of autonomous artificial intelligence and that could potentially affect autonomous vessels. And so that may be something to look out in the future, and whether the UK feels that it will go down that route. I certainly hope they don't, because there is a very real possibility of a clash with maritime conventions on civil liability, and there's no exclusion in the draft regulation of any incidents involving listed civil liability conventions. So thank you for your attention, and I shall now clear the screen and hand over to Professor Leah Athanasiou.
Thank you very much, Professor Bogen. I am really happy and honored to join this very distinguished panel, and I would like to extend my thanks to Professor Sawyer for this invitation and to congratulate him for all these activities despite negative circumstances. So the third presentation concerns the cross-border insolvency issues and the increased application of model law, of UNCITRAL model law. This question really merits to be on the agenda, both from a factual and legal point of view, but also from a political point of view. We have witnessed during the last decades an increase of insolvency proceedings with multi-state connecting factors. At the same time, we were going to witness very probably an increase of such proceedings following the COVID-19 pandemic, although now the focus has been put on state aid measures. Legally speaking, we witness also an evolving internationalization of insolvency law, and we have now active two main parallel regimes: the European regime until now, for UK also, And I will refer further now to recast regulation 8048 of 2015, and also a second parallel regime, the model law of IISTL. If we see that now from a political point of view, we understand that the change from one system to another has a quite important political implication due to Brexit, but also for another reason, because progressively we have an interstate competition for attracting insolvencies. Indeed, UK has been placed 14th on World Bank's list for resolving insolvency. So other countries wishing to become a worldwide insolvency hub may also try to get some of this precious material. I present the existing parallel systems in three concentric cycles. In the middle, you may see the regulation, the European regulation, the recast regulation, because it has a limited territorial scope, but at the same time, an exclusive and more penetrating regulation. The second circle is the model law, and the third one is the different national rules, specifically conflict of laws rules that will govern the relation after Brexit. Now, the main question here is the following. Does it really matter if we pass from one system to the other? In order to have a systematic reply to this question, I thought it would be good to present briefly similarities and differences of the two systems. I will go quite quickly regarding the similarities, but it is important to have them in mind. Both regimes, they establish uniformity in cases with cross-border links, embracing what we call the doctrine of modified universalism. What does it mean? That both systems, they accept the principle that only one forum may claim and exercise international jurisdiction over the assets and liabilities of the debtor, irrespective of their location. And in order to achieve the choice of this one forum, we have adopted in both cases multilateral instruments based mainly on procedural rules. Regarding the recast regulation, we have also conflict of law rules. In the ML system, we have only procedural rules. Both systems, they put the emphasis on the recognition of foreign insolvency proceedings. And this recognition is linked to the central term of COMI, Center of Main Interest. What does it mean? That the most suitable forum to open the proceedings, the main proceedings, is the forum where the debtor conducts the administration of its interest on a regular basis, which is recognized by third parties. In order to avoid conflicts, we have established in both systems the presumption of the register office, which is a rebuttable presumption. And we have also offered the possibility of opening secondary proceedings in the location of establishments, meaning by that the place where non-transitory economic activity with human means and goods or services take place. Here are the main similarities, and that's all, because afterwards we have the main divergences which will create some problems and concerns. The main divergences, I start by the legal nature. Recast regulation is a binding, directly applicable and enforceable instrument, while the ML is a non-binding instrument depending on national enacting measures. It means that for model law, in fact, it works as a guidance for a domestic regulatory framework. Is a text to be completed by national legislators, and that's why if one reads the model law, it will see brackets within the text. It means that no one can have a clear picture about the ML unless it can compare it with the national enacting legislation. Regarding interpretation, there is no doubt that the recast regulation has a uniform interpretation based on EU autonomous concepts, which is supervised by the European Court of Justice. The same principle, but less ambitious, we can find it in the ML, because there, Article 8 requires also uniformity in interpretation in accordance with good faith. But here, the supervision is effected by national courts. For that reason, IISTL itself has issued 2 guides to help uniformity in interpretation. Main difference, the territorial scope. As I mentioned before, regulation has a stable, limited territorial scope, which includes European member states with the exclusion of Denmark and now, unfortunately, UK. On the other hand, the territorial scope of model law is expanding. For the moment, 46 states, 48 jurisdictions. And as you can see on this slide, similar international coordination efforts are also adopted in various places of the world, North Europe, Latin America, Central and Eastern Africa. What it is interesting to mention is to compare the European countries, more specifically the EU member states, which have adopted ML. As you will see, they are just a limited number. Only Greece, Poland, Romania, Slovenia, Gibraltar, the status of which is not very clear after Brexit, and UK, which now a former EU member state. No other European country, European member state has enacted model law, which probably will create problems also in the future. Regarding third countries, obviously, those third countries, they are not bound by the regulation. However, it is worth noticing that important countries all over the world have now adhered to the IISTL model law. As you can see there on this slide, we have US with the notorious famous example of Chapter 15, Australia, Canada, Japan, South Africa, South Korea, OHADA countries, Philippines, United Arab Emirates, and Singapore. I mentioned there with reservations because Singapore tries at the same time to be an insolvency hub and an arrest hub, and this is difficult to comply at the same time. Now I proceed with the 2 main differences which are most important for the issue discussed today. And these 2 differences concern the first one, the recognition process, and the second one, the effects of recognition. As regards the recognition process, under the European regulation, this is automatic and mandatory. Under the model law, a recognition decision is needed by the host state, although a mechanism with minimum requirements is established. In addition, although both systems rely on the central term of COMI for main proceedings and establishment for secondary proceedings, there is a huge difference. Under European regulation, the determination made by the first national court is binding on all other courts. So if one court says that I confirm that COMI is in my country, that is binding for all the other countries. That is not the case under model law. In the second system, the national court will examine when assessing the application for recognition whether the foreign proceeding has been indeed opened on the debtor's COMI. And in this case, only one foreign main proceeding may be recognized without restriction for non-main proceedings. There is also a difference in crucial time the assessment under regulation is made 3 months before the opening. Under ML, it's made on the application for the gogression. This is the right timing. In both systems, we have safety valves, the public order. Recognition may be denied if there is contrary to public order, but one can imagine that is very difficult to apply in European context due to the mutual trust between member states, and perhaps easier to apply when we come to the ML system. And I come now to the last comparative difference. It has to do with the effects of recognition. In fact, when we are under the European regulation, the effects are determined by the lex fori concursus. That is not the same under the ML system. There, we have a list of automatic effects which are provided in a standardized manner by the model law, and sometimes completed by the national legislation. So these automatic effects are normally state of individual action, state of execution measures, suspension of right to transfer, etc. We have additional discretionary relief upon recognition for both main and non-main foreign proceedings, and also the possibility of provisional relief upon application during the period from application to recognition. What is a general remark here? That when we are in the field of the model law, there is a general tendency to align the effects of the foreign main proceeding to those of domestic insolvencies, and we can see that very clearly in the British model law. So there is a quite important difference regarding the effects. And the last difference has to do with the conflict of law rules. European regulation provide for a clear system that lex fori concursus is in principle applicable with some exceptions, while the model law has no provision regarding the conflict of law rules. That obliges us to go back to the national provisions of private international law. And also another lack, we have no provision regarding the groups of companies in ML, although some provisions do exist in the European regulation. In this table, I tried to make a comparison regarding the activation of the regimes. It's quite complicated. The idea here is to understand that for us, and when I say for us, I mean for the remaining European countries, COMI is the main point. If COMI is within the European Union, regulation applies. If COMI is outside the European Union, model law will apply. Parallel proceedings are possible when there is a contested COMI. I mean, when there is a multiple location within European Union and third countries, and that it is very possible to happen when we have groups of companies, because some subsidiaries may be within Europe, some subsidiaries outside Europe, and then the parallel application of the two regimes is very possible. Having in mind this systematic comparison, I come to my third part. How is the situation as it stands now? For somebody outside UK, was really difficult to follow the evolution. We understand now that following the EU Withdrawal Act of 2018 and the new Withdrawal Act of 2020, there is a clear distinction. Old proceedings, as is clearly said here, will continue to be governed by regulation, recast regulation. So we have a preservation of the status quo and, in fact, a protection of legal certainty concerning the main proceedings which were opened before the end of the transition period. In the late UK-EU Trade and Cooperation Agreement 2020, there is no reference on cross-border insolvency. Therefore, we are legitimate to think that as far as this matter, there is no any other bilateral agreement or any other bilateral solution. So what will be the situation as it can be understood now regarding the new proceedings, the proceedings that will come after the end of the transition period? One should distinguish between inbound proceedings. It means the proceedings that are opened in a third country and seek recognition within UK, and the outbound proceedings. For the inbound proceedings, it seems that British model law will apply without requirement for reciprocity. That means, and it is clear, that no restriction exists anymore as regards the opening of proceedings in UK for companies with COMI in European countries. No applicable law rules apply, and then it is very possible to have multiple proceedings in relation to a single debtor. For the outbound proceedings, there is no more automatic recognition. Cases that have been handled now in UK will not be recognized automatically. Bilateral issue, perhaps the other country will apply VML, as it is the case in Greece. Other countries will apply the private international laws, as it is the case in Germany or in France. The result is that the UK practitioners will have to initiate local proceedings or submit applications for recognition in every country where the debtor has subsidiaries, activities, assets, etc. To that point, and this is my last point, in fact, I had the intention to finish with an example to see how this will work in practice, but I will prefer to end with this because this is a new ancestral model law on recognition and enforcement of insolvency-related judgment. Has been adopted in 2018. And this new model law is intended to fill the existing gaps. No country has yet taken legislative steps to adopt amendments, but I think for the UK it will be very useful for the following reasons, because if one incorporates this new model law, it applies to foreign judgments that arise from or are associated with insolvency proceedings. And it means that it creates an obligation to recognize and enforce insolvency-related judgment in a mandatory way. So it would be an exception to the well-known rule in GIPS. I understand, and that is my last point, the example that I had the intention to present to you, how things would work in case a shipping company with an office in UK and administration in Greece would have to cope with insolvency proceedings. But I think it could be a question, or I can share with you my slides. What it is important to note is that I don't believe that this change and difficulties that will arise from the passing from the European regulation to model law will really affect the maritime relations between UK and Greece. It's further more important than just the insolvency regulation. Thank you very much for your attention. I'm at your disposal for any question. Professor Sawyer, thank you again for your hospitality.
Thank you. If we have the whole panel, I realize that we still have majority of the participants with us. So I think that's a ticket to ask some questions. I would like to start with Simon Kroll. There is one question from Carlos who says that he understands that the enforcement of British judgments is still possible, but perhaps a bit more complicated. Do you think that this complication would make arrest of ships in UK less attractive?
I think my answer to that is probably not. There's a series of reasons for that. First of all, the arrests in the UK are governed by a freestanding convention, which is totally unaffected by Brexit. But also from a practical point of view, you're going to be arresting a ship for one of two reasons. The first reason is you're wanting to obtain security for a claim. And therefore, what you're really seeking to do is to arrest the ship in order to obtain security. What you want, therefore, is security. My tip, therefore, would be is you make sure that your security, if you're going to get it subject to a particular jurisdiction, an English jurisdiction, is to make sure you've got an exclusive English jurisdiction clause, and then you're within Hague, and you can enforce that security within that. But normally, the only other reason, apart from obtaining security, is that that's your basis for founding jurisdiction, and that's the only basis you have, in which case you will then be able to enforce, if that's your only basis, and it remains a claim in rent, against the ship, and that remains the same as it would have done before. So I don't think it makes any difference to enforceability judgments. I can see that when you're getting your form of security, you may want to have in mind precisely what any jurisdiction provisions provide. But otherwise, I think it should remain as attractive as it was, indeed, as any other arrest form would be.
Thank you, Simon. Thank you for the question. Carlos has a question. I think maybe we should pass that to Simon. He says he wonders whether providing insurance services through subsidiaries would affect the quality or competitiveness of insurance companies following Brexit. Simon, do you want to take that?
I can't think that it would, actually, but I mean, I think we'll have to see how things pan out. But I would have thought the P&I club's going to be carrying on much business as usual. I mean, after all, I mean, they're not entirely unused to having foreign subsidiaries. I mean, when I was in the London club, you know, it was sort of officially sort of registered in Bermuda, and you know, I think sort of there was sort of a telex chain, as it then was, between London and Bermuda. You know, I don't think it will make a difference. No, I don't think it'll be less competitive. But you know, feel free to shout me down and enlighten me.
I don't think so. Simon, do you want to add anything on that?
No, I can't see any reason why that should affect the provision of insurance services. There are things will be affected, but I don't think that will be it.
Okay, thank you both. Leah, there is a question. Maybe you would like to take that one from my esteemed colleague, Professor Tettenborn. Does Article 2(9)(4) of the EU Insolvency Regulation about the locus or property ownership of which is governed by a public register cause difficulties over ship arrest? That is a question and a half, Leah.
Yeah. It has to do, thank you, Boris, for the question. Let me check. It has to do about the definition of the location of an asset, and it is related to the application of Article 8, third parties' rights in rem. So the idea under Article 8 is that third parties' rights in rem are preserved as far as the asset is located in another member state. And where is located, SIP register is considered as the fictional location of the asset. So if I say, let me give you an example. If a French ship is arrested in Greece, if it is French flag, then is arrested in another country, and then the rights of secured creditors are protected. But this is only for the application of EU regulation. The same rule does not apply in the context of the model law of UNCITRAL model law, because model law has no provision regarding the applicable law rules. So as far as the European member states are concerned, these rules continue to apply. It does not play anymore under the context of model law.
Thank you, Leah. I think that's a very, very comprehensive answer. I would like to turn again to Simon. Well, either of the Simons will do, really. But I suppose more Simon Kroll. But I know Simon has an interest in the area as well. My Simon, Institute Simon, I mean. There is a question from Dr. Loludas. What could be the implications of rejecting the UK's application to join the Lugano Convention? Any legal reason to refuse it following the trade agreement?
Well, the implications are that we won't be entitled to accede to the Lugano Convention, and to say the UK won't be entitled, because it does need agreement from all the parties, which means the EU parties. So in a sense, the EU states have a power of veto. So that's the obvious implication. Is there any legal reason to refuse following the trade agreement? Well, I'm not sure there ever was a legal reason. I think the reason that underpins all this has got as much to do with the politics of the situation, and perhaps even to some degree the economics of the situation, and to what extent those factors drive, if you like, what may be perceived as being part of a trading group. And I think it might affect the extent to which the trade agreement is seen as an adequate basis to go forward. My guess, and it's only a guess, is that as and when this is revisited, there's a strong chance that the EU nations will allow the UK to join Lugano. But it's not always easy to predict these things. I don't know what the other side thinks.
I would agree with that. The other point I would make, and it's something I only sort of became aware of a few weeks ago, is that, Luke, if the EU does say, okay, you can come in, there's a 3-month hiatus before the convention applies. And I think that's going to be very complicated, and maybe more work for lawyers, but yeah, it is going to be complicated.
There is a question linked to that, Simon. Simon Crowell, maybe you can follow up your answer. In the event UK doesn't receive EU's approval, for example, Lugano Convention, what difficulties one face with respect to recognition and enforcement of judgments issued by the High Court in London?
Well, I think on the assumption that judgments are portable in the way that they are intended to be under the recast and Lugano regime, the difficulties one will face really are questions for all judgments will need to be enforced in the state of which the relevant party is resident, and that will be, depending on what that state is, and depend on the local law there. And you will ordinarily have to commence your own set of proceedings to enforce the judgment. In almost all states, it's possible, but it's subject to their own regimes. It normally takes a bit longer. There may be more uncertainties, and there will usually be more costs. And all of those things is a reason why UK lawyers have been extremely keen on Lugano, because the portability of judgments is perceived to be a competitive strength. And I'm sure it makes sense for most people. However, it's not impossible. I think indeed it is very possible. And most of the time it will be possible, but I think it will just be more complicated and more costly. And I think that's the implication, rather than it will be rare, I think, that you'll be unable to enforce.
Thank you, Simon. Questions coming in, so we carry on a few more, if you don't mind. There is a question, maybe, which relates, Simon Bowen, to your talk. Will leaving the EU have any effect on vessels applying for or obtaining a polar waters operation manual required for any navigation that includes travel through polar waters? You are on mute.
I have to say, I don't know, but I mean, I'm trying to think, what is the source of a polar waters operations manual? It sounds like an IMO regulation. I mean, I would have to do my quick search on Dr. Google to find out more about that. But I'd like to know the source of that regulation. And
I think it's linked to the SOLAS, because it's the Polar Amendment is an amendment to the SOLAS. So I don't.
In which case there would be no change at all.
Yeah, I don't expect so.
No.
I mean, we have QC here, so which can correct us if we are wrong. But Simon, I don't think there's any difference in that sense.
I think it will be unaffected, but I say that on the basis of sort of general principle rather than specific knowledge.
Thank you. I have a question to whoever wants to take it. So I don't want to put anybody on the spot from an academic, which is an academic question, I believe. Our good friend George from World Maritime University. Listening to the presentations, he says, I'm wondering, while we had to spend so much time and effort and funds to interpret existing rules, how much effort will it be required to ascertain, find the applicable laws post-Brexit? Will it work better for UK or European courts, better in shipping disputes? Whoever wants to take it, I mean, I think Simon Kroll, it's directed at you to a certain extent.
I'm happy.
Professor Leah as well will take it.
Well, I think 2 points. First of all, one of the points I made and will repeat is that I think there are much more significant areas in which nothing changes than there are in which there are changes. So I think most people operating, particularly in the maritime and some aspects of the commercial world, will see very few changes. Insofar as there are changes, those changes are not driven by, those changes are fundamentally driven by political considerations. I don't think on the whole, the result from the legal perspective is going to be simpler, clearer, and more straightforward. On the whole, it's probably not going to be. But it depends, of course, in the end, what the UK chooses to do. If the UK chooses, through its own approach, to adopt something very much like what the EU is doing, well, the differences are going, in most areas, to be hard to spot. Choose to do something different, well, then there may be differences. And those differences may be more acutely felt if one looks at it on a pan-European level. But if one looks at it from a UK perspective or from the EU perspective, then the crossovers may be limited, in which case it will make very little difference to people's lives.
Thank you. Leah, you had something to add.
Yeah, thank you, Boris. In fact, from a foreigner's point of view, I think that it will cause an increase of cost, inefficiency, and legal uncertainty. And regarding specifically the field I was discussing about, it is quite astonishing if you imagine that English courts, they were precipitating to grasp the coming the UK in order to control the procedure for many decades. And so in order to have an automatic recognition all over Europe. And now we see the other way around, that their proceedings, they will not be automatically recognized in other countries, and they will have to have multiple proceedings. So in some areas, and I think that it will affect shipping also, we will have such legal uncertainty, additional cost, and I think that it will be in profit of other countries, European countries, that they try to attract re-establishment. Of course, UK knows better than everybody else how to react to that, but it will be definitely a change in the handling of maritime disputes. Thank you.
Thank you. Simon, you wanted to add something?
Yes, I was just wondering whether one possible knock-on effect from this might be increasing use of in contracts of references to arbitration rather than to high court jurisdiction. You know, because then you've got the enforcement problems, you've got the New York Convention. It's nothing's affected. But Simon, or Leo, I don't know what you think about that as a possible trend.
I think it's a likely trend. It's an obvious thing for people to do. The other thing, which is, I think, perhaps going to be more commonplace, is one's going to see exclusive jurisdiction clauses, which are genuinely exclusive rather than asymmetric, so that people can, as much as possible, retain what feels familiar and the status quo. And if people do that, I think the differences may be, perhaps not so acute, but there will be some differences. And I don't disagree with Rosa Athanasiou when she says that there's an opportunity for other people to try and take a part of the market that London's had for a while.
Well, thank you, everybody. I would like to thank all our speakers at this stage and also participants for the interest they have shown, for the questions they posted. At the height of the event, we had 200 participants, which is very impressive. So very much thank you to everybody who made this event a great success. And of course, as the director of the Institute of International Shipping and Trade Law, it's my duty to make a quick reminder at the end. Our next event, as I said at the beginning, will be on 11th of February on distributed ledger technology and blockchain in shipping sector. We hope to see you there. And I would like to take this opportunity again to thank everybody. Stay safe, stay healthy, and I hope to see all of you in person soon. Thank you very much, and thank you for your interest in the event. Thank you.